We're in for a real treat, thinking about how to compensate, in particular, victims of terrorist acts and other grave mass casualties. And I guess a real treat is a bit awkward to say given the subject matter, but I say that because of the person who put the panel together, and I consider him to be one of the most outstanding lawyers in the country in terms of dealing with rectifying, remedying a wrong, and the entire human condition associated with that. And that person is Ken Feinberg, who's the founder of the Feinberg Group in Washington here. But the special master for the September 11th Victim Compensation Fund, setting up compensation schemes for a number of tragedies, including Virginia Tech, the Sandy Hook Elementary School, the Boston Marathon, BP oil situation, the list goes on. And so, Ken, I'm going to turn the floor to you, but thank you so much for all that you've done in terms of your work in this area. You've reached so many people. But also, thank you for your leadership and support of this conference today, and we look forward to your panel.
Thank you. I'm really here today, leadership. I'm here because, one, Frandy Wolf, every couple of days sends emails. And secondly, you do not disappoint Ike Sorkin. I've learned over the years, you do not disappoint Ike Sorkin. We've got about an hour. We could spend an entire seminar at this law school talking about the subject of terrorism compensation. Now, before I introduce these two experts on my right and left, there are some philosophic problems with all of this, you understand. Why special compensation for terror? Bad things happen to good people every day in this country. There's no special compensation. Hire your lawyer, you hire your lawyer, go to court, judge and jury. That's the American rule of law. That's the system. Why terrorism compensation? Well, just an overview here. One, it's not so easy to litigate against terrorists. It's not like you get hit by an automobile and you go to court. Litigating against terrorists is not an easy undertaking because of the law of immunity, sovereign immunity, no jurisdiction, etc. Second, winning against a foreign terrorist or foreign government is never easy. The terrorists may be dead. Who are you suing? Foreign governments have immunity. Three, and these guys know this, when you think about suing foreign governments or terrorists if they're alive, you run into a major political thicket where, in good faith, your State Department, your politicians may see such litigation. It might be just, it might be proper as against these victims, but it raises all sorts of political questions about foreign policy and the dynamics between the United States and foreign governments. So there are practical and existential problems. And that's where special programs arise that might be available to compensate victims of terrorism. But it's not a sure thing. I get involved, 9/11, the current Department of Justice, the current state-sponsored terrorism compensation statute. I get involved way after the fact. Policymakers and others have already decided there ought to be a special program. They call me. But I'm not there at the genesis of these programs. I don't decide these issues. Whether or not there should be a statute at all creating special rules of compensation for victims. Not me. I'm a Johnny-come-lately. Ken, the law is there. You helped design and administer that law, but I'm not the one that decided whether or not there ought to be a law. Now, before we get into the most current statute, let me introduce Jim Kreinler to my right, Steve Perlis to my left. There are a handful of lawyers in this country you can put on two hands, some are in the audience, who really understand this stuff and have been involved in getting it happen so that I do get a call from a president or an attorney general to implement a program. But these guys are there urging Congress and the administration to do something about a particular problem. Iran, Lebanon, Sudan, Saudi Arabia. These are the guys that have to be on this panel, although there are a couple of more in the audience who could be with us. And I want to start off by asking Jim and then Steve, before we get into any mechanics, how did they get involved in all of this unique area of public policy, compensating victims of foreign terrorist attacks or attacks in the United States from foreign terrorists? How did they make this their life's work? How did it happen? Planning, serendipitous, by accident? And then we'll get into some of the details, but I'd like to give both of them a chance to provide a little bit of background as to how they got involved in this whole subject matter that brings us here together. Jim.
Well, thank you, Ken. It's a pleasure to be with both of you. In my case, it was luck. It was fortuitous. Aviation accident litigation began in 1952. My dad handled the first case where anyone proved the cause of an accident. Prior to that time, it was considered an act of God. So since 1952, we had been the preeminent aviation firm. Pan Am 103 happened December 21, 1988. At that time, the airline was protected by the Warsaw Convention, which limited liability to $70,000 a death unless you could prove willful misconduct. We were visited by a number of the Pan Am 103 families, took those cases, and from 1988 through 1995, proceeded against Pan Am, won the trial, won the appeals, settled all the cases. In the aggregate, those cases were settled for $550 million, which becomes significant when we talk about Ken's work in 9/11. In 1996, Congress passed a new law that the Effective Death Penalty and Anti-Terrorism Act that permitted suits against state sponsors of terrorism, and we sued Libya. I personally got involved in the case. I'd been in the office for a couple of years, and when Pan Am came in, there was a lot of publicity. Some of you with as much white hair or absence of hair as the three of us will remember the stories about the scandal in Pan Am, the corruption, and when we got into the case, I had been in the DA's office. My dad said, this case involves scandal, crime, murder, sexcapades. It's perfect for you. And that's how I began my career. In 1996, we sued Libya and ultimately settled with Libya and recovered $2.7 billion for the 270 victims, $10 million a death. When 9/11 occurred, we had been engaged in settlement discussions with the Libyans for over a year. The press had reported that negotiations were in fact progressing. So the day after 9/11, we got our first calls and visits as being the one firm engaged with Libya, who of course was responsible for the Pan Am 103 case. I'd take up far more than the hour in describing the twists and turns of 9/11, but our work in 9/11 did grow out of the work we did in Pan Am 103. From 9/11, 2001 until 2008, I was doing both Pan Am 103 and 9/11, and I've been working on the 9/11 case now for 15 years. Hopefully, while you're all still in town, or mostly in town, this week we'll see Congress override the president's veto of JASTA, a very narrow law that will conclusively return the law to where it was 12 years ago and permit our suit against Saudi Arabia to go forward. So that's the short version of how I wound up in this chair.
Steve.
Thank you. I suppose my first blush with this genre occurred in 1979. At the time, I happened to be working for the Senate. My boss, Ted Stevens, was the Republican whip and acting leader during the Tehran hostage crisis, and that issue for the year and some months that it lasted wound up on my desk, and quite serendipity. I left the Senate staff in late 1981, early 1982. In 1986, again in a very serendipity fashion, I began a case called Prinz versus the Federal Republic of Germany. And Prinz was a 13-year-old U.S. national. He was a U.S. passport holder, an unemancipated minor, living with his American business family in Europe, who was trapped in Europe on Pearl Harbor Day. By the time that litigation ended in 1994 or early 1995, Germany, by settlement, had agreed to compensate all individuals who were in Nazi concentration camps as U.S. passport holders or American servicemen who were sent to concentration camps instead of prisoner of war facilities. About a year later, there was an event in Israel involving another New Jersey family, Elisa Flatow. Elisa Flatow had been a 19-year-old Brandeis University junior who had gone to Israel to study for a year. If you think back to 1995, the Middle East was not what it was today. It was actually a pretty peaceful place. Oslo had broken out. The Iranians could not stand peace, so they engaged in a systemic pattern of bombings against Western targets in Israel intended to derail the Oslo peace process. That bombing campaign was quite successful. Oslo collapsed. Elisa Flatow was the first, not the only American who was killed in those series of bombings. In 1995, Jim and I found each other up on Capitol Hill. He was there for the Lockerbie families. I was there for the families of several students who had been killed in Israel. And we amended a statute called the Foreign Sovereign Immunities Act. And that statutory change is now codified at 28 U.S.C. 1605 Big A. Sometimes it's referred to as the Flatow Amendment. That statutory change that Jim and I got back in 1995 opened the door for litigation against state sponsors of terrorism. We've also used another statute called the Anti-Terror Act to proceed against private actors who handle funds or materially support terrorist organizations. Those of you who are here from Hebrew University had an event during the Second Intifada at your facility, and we used the ATA as a vehicle for helping to obtain compensation for one of the Americans who was killed in that event. And compensation is a dreadful term to use, and I really would like to get at this early. I don't think there's enough money in the world to compensate somebody for the loss of one of their children or a parent in an event like this. We look at the movement of money. And for us, winning judgments isn't enough. This is really about moving money from material supporters of terrorist attacks, whether they're states or private actors or banks or other money launderers. The movement of funds has a deterrent effect. So when I talk about compensation, I don't think of it in the conventional sense, like a normal, like you were talking about a vehicular accident. It's not that kind of litigation. It's about taking massive amounts of money away from the material supporters and other underlying infrastructure behind these attacks in the hope that by taking money away from them, we're going to deter people from doing that in the future.
Now, the law, there are two laws front and center right now as we meet here today. I'm the Justice Department appointed special master to compensate, in quotes, victims of state-sponsored terrorism. Jim mentions another law just vetoed by the president dealing with Saudi Arabia and opening up American jurisdiction to lawsuits against the Saudis. Put that aside for a minute, that second law. Some of you are here particularly to learn more about the first law I mentioned. The law currently on the books, we're now working at the Justice Department, preparing to determine eligibility and make calculations to compensate eligible victims of state-sponsored terrorism. These two guys were instrumental, along with a few others in this crowd, in getting that law enacted. And I want to start by asking Steve and then Jim to focus for a minute, what does this law do, and how were you able, working with some of your colleagues, to convince Congress to set up a special compensation package for victims of state-sponsored terrorism?
Thank you. By the way, a couple of my co-counsel on that project, John Eves, who's over there, and Mike Miller, and if I've missed anybody else, I apologize, but they're out there. You'll learn something, guys. Go back to white-collar crime, and you think about a well-publicized white-collar crime in the United States, Madoff. And what the Justice Department does in Madoff, every time it takes in a fine from a bank or any other institution that helped facilitate Madoff's crimes, that money doesn't go to the taxpayers. It goes through a Justice Department program called remission. And that money is remitted back on a prorated basis to the victims of Madoff's crime. And it occurred to us that we could do the same thing. We could take, and in particular, we were focused on the massive fine, the $10 billion fine that the Justice Department imposed on BNP Paribas for laundering roughly $130 billion of Sudanese money through the American banking system, illicitly laundering that money through the US banking system. And we actually made a remission application to the Justice Department for those funds. And without being too critical of my friends at the Justice Department, they kind of slow-rolled us into oblivion. They never said no, but it was very clear that the program wasn't going forward. And we thought that was inappropriate. So we went to Congress and said, since the Justice Department will not create a remission program for using fines from people that facilitate the movement of state-sponsored terrorist funds through the United States, will you do it for us statutorily and force justice to do what they will not do by act of discretion? And that's really how the program started. But the truth is, you don't give yourself enough credit, because there's another program out there, and that's the Libya Program, which is before the Foreign Claims Settlement Commission. That program is now 6 years old or 7 years old, and there are only a couple of hundred claimants or 250 claimants. When you say you're the Johnny-come-lately, that may be true, but you're the guy that makes the program work. You're going to have thousands of claimants in your program, and you're going to be done in 90 or 120 days. People aren't going to have to wait 6 or 7 years. So don't sell yourself short. The guy that runs that program is what makes it really work. I don't want to go back to a program like what we see at the Foreign Claims Settlement Commission, where I have 6-year-old applications that are still in process.
Yeah.
Jim?
There's a fundamental problem with the law as it's passed, and the problem arises because Congress didn't pay attention to the two types of terrorism victims that exist. On the one hand, you had the 270 Pan Am 103 victims and the 9/11 victims. And let me take a minute to explain what happened there. In Pan Am 103, all of the death cases were eventually settled for varying amounts, taking account of age, earnings of the decedents, and settlements ranged from $575,000 then on single non-dependency cases, children who were killed, survived by parents, to a high of $13 million. When it came time to resolving the case against Libya, we believed that everyone should be treated the same. Gaddafi subcontracted the attack on Pan Am 103 when the Iranian-sponsored cell for the Liberation of Palestine General Command was busted. Gaddafi was reputedly paid $10 million to mount the Pan Am 103 attack. So it became enormously important for us to insist upon a settlement of $10 million for every victim. When 9/11 occurred, in mathematical terms, there's 10 times as many death cases as Pan Am 103, plus injury and property damage. You'll remember that Congress passed a law to protect the U.S. aviation industry, to save American and United from overwhelming suits. Ultimately, Ken's program, the VCF, the Victims Compensation Fund, successfully compensated 98% of the victims. There were 200 who persisted in suits we handled against American and United, and those were settled. But the math is again important because in rough terms, the money paid by Ken's VCF on the death cases was 10 times what was recovered in Lockerbie. Variations based upon age and earnings. In 9/11, we have always taken the position that every one of the 9/11 victims who were murdered, that their families should receive $10 million regardless of nationality, earnings, ages, etc. Here's where Congress, in my opinion, really made a big mistake. There is a difference between plaintiffs who have not gotten any compensation at all, and Steve has been representing those plaintiffs against Iran, and the Pan Am 103 or the 9/11 plaintiffs who received varying amounts and should, when it comes to taking money from the country that sponsored the attack, be treated equally. I think what Congress intended to do in this program was compensate Steve's clients, the victims of Iranian terror. What Congress did not take account of is our claims against Iran in the 9/11 litigation. In 9/11, for my clients, 850 death cases, we have a partial judgment on liability against Iran, a liability judgment across the board. We have a partial judgment on one element of damages, pre-death pain and suffering, $2 million plus the multiplier of 3 plus interest for about $8.66 million a person. And now we're getting a couple individual cases. What Congress did in creating this statute, and they did it accidentally, is create a statute where the only 9/11 plaintiffs who can recover from Ken's fund are the few who did not go to the VCF. Because if you went to the VCF, you've been paid 100% of your claim. So of the 100 people who didn't go into the VCF, who sued American and United, only those with final judgments against Iran can participate in Ken's fund. And it does not make sense to have a situation where 1 out of 20 9/11 victims can go into the fund. It also doesn't make sense, in my opinion, to have them receive varying amounts. They've already received varying amounts from the VCF for settlements with American and United. What does make sense, eminent sense, is for all the 9/11 victims to be treated equally. Now, Ken and I and Steve have been talking about this fund for a long time. And what I was hoping for is a fund that would compensate all the 9/11 plaintiffs for a fraction of what they're entitled to from Iranian funds. I don't know if many of you are familiar with Iran's role in 9/11. It's a smaller role than Saudi Arabia. Saudi Arabia directly funded the hijackers, gave them money, apartments, flight lessons. Saudi agents did that after years of supporting al-Qaeda. In Iran, the claim is twofold. Iranian intelligence worked with al-Qaeda, among other terror groups, and Iran permitted the hijackers to transit Iran on the way to Afghanistan without stamping their passports. If their passports had an Iranian stamp, the 9/11 hijackers could not have gotten on the American and United flights. So we have a claim against Iran that should be much smaller than funds received from Saudi Arabia, but it should be on an equal basis. So now we have the anomaly where a handful of 9/11 plaintiffs can go into the fund and receive some money in varying amounts, but it's not the way the system should work.
Now, let me spend a few minutes with my colleagues here. This will be helpful to everybody at a basic level. I am now the special master appointed by the Justice Department administering this program to compensate eligible victims of state-sponsored terrorism. Not just any victim, state-sponsored, as articulated by Congress or the State Department. Iran, the Sudan, certain years involving Cuba, but a very, very narrow very narrow box of eligibility claims. Now, I want to ask Steve, how does this program, this is a 10-year program, I'm about to administer or distribute, authorized by the end of this year in a few months, about $1 billion, paribus, money that came in from that fine. I want to ask Steve how this program might work. Once I distribute $1 billion, I have no more money, and yet it's a 10-year program on the assumption by Congress other money may come into the program to be distributed on an annual basis. Steve, where is this money going to come from? Once the $1 billion is distributed to eligible victims, how do we replenish the pot?
The first terror victim fund that you administered, the 9/11 fund, used taxpayer dollars to provide true compensation to those victims. There was no designed deterrence in that fund. It was a true compensation fund. The second terror victim fund, the one that you're now administering, from my perspective, comes back into the world of deterrence, because that fund has no taxpayer dollars in it. That fund currently is composed of a small portion of the B&P fine and sets out a formula by which future fines against banks or other money launderers who are moving funds of state-sponsored terrorism through the United States are impounded by the United States and then added to that program. Effectively, what's going to happen is when the Justice Department goes out and prosecutes these money launderers, the Justice Department never puts anybody in jail. That's just not part of their program. Instead, they say, if you don't want to go to jail, you have to pay a big fine. And by statute, that fine is now going into your program to be distributed to various eligible terror victims. And I hope what's going to happen is that the fact that you have thousands of terror victims who are going to be looking to this fund, I hope that energizes the Justice Department so that they go out and they are engaged in more robust prosecution of money launderers, and that you have bigger fines. And I have certain structural problems in the fund. I have, where Jim has several really large cases, I have a very broad spectrum of cases. My portfolio is very different than Jim's is. So I have, for example, Iran clients who are ineligible for your fund because we've done too well for them in enforcing their judgment. I have Iran clients or Sudan clients who've received no compensation, who have applied to your fund, or just talking to Mr. Eves, we're finishing up this week and we're going to file another large block of claims with your fund. But eventually, as the uncompensated people get caught up, everybody else should benefit from that fund. For that to happen, the Justice Department really has to put the hammer down on money launderers. There is a huge deterrence built into that fund, including the little-known reward provision that you and I have talked about, where if someone goes out, and it's almost like a key tam provision, where if someone can go out and identify a money launderer for terrorist funds and brings that to the attention of the Justice Department, that individual is going to, or for example, if it's someone like me and I'm doing it on behalf of my clients are going to get their payment out of the fund front-end loaded, so they'll get some money. There's a real reward built into that program for people who are actually out hunting money launderers.
Notice what Steve is saying. I may be able to distribute, this program may be able to distribute over $1 billion by the end of this year. Congress said the program will continue for 9 more years, but the Treasury is empty. Whether there'll be sufficient funds in year 2, year 3, year 7 to distribute additional dollars to eligible victims depends on enforcement. Now, Jim, let me ask you this question. This statute again now, we're getting a little technical. To be eligible, you have to be a victim of state-sponsored terror. The Iranian hostages, the Lebanese Marine barracks bombings, the African embassy bombings in Tanzania, Kenya. You have to be a victim of state-sponsored terror, but that's not enough. You also have to have in your hand, when you apply to this fund, a final default judgment from a federal court saying, in effect, you sued, Iran didn't show up. default judgment entered, no assets in the United States. The Sudan didn't show up. Cuba didn't show up. You have a default judgment. Yet, the statute excludes from that default judgment requirement all of the Iranian hostages from '79. Jim, explain to the crowd why you need a default judgment unless you're an Iranian hostage and you don't need or you can't get a default judgment.
Yeah, well, the statute's written that way. On 9/11, we can get default judgments, final judgments, and we're in the process of doing it. As I said earlier, it's not what we want to do because we want the people to be treated equally. And it was our hope that by getting partial default judgments of 8.66 million across the board, that could put us into play with equal treatment, but that's gone. One thing about where the pot's going to be replenished from. Here's my prediction. Before the 10 years are up, I believe there'll be a global resolution of all Iranian terror claims. I mean, you all have read the paper, and the Iranian leadership is disappointed that when they put pen to paper on the Iran nuclear deal, they suddenly didn't get back $8 billion. Well, they're happy to be able to get Boeing and Airbus aircraft, but until Iran comes off the list of state sponsors of terror, they're not going to get what they want to get and what some people in Iran thought they were going to get. Sanctions are going to remain in place. That makes it impossible for Iran to really engage and profit in the world community. So rather than a piecemeal approach, I think there's going to come a time when Iran is going to follow the Libyan example and say, we want to get off the list of state sponsors of terror. What do we have to do and how much do we have to pay? And I'm hoping that the fund can be amended so that when that day comes, all the 9/11 plaintiffs can be treated equally, whether or not we've already recovered from Saudi Arabia. For Sudan, it's the same thing. I mean, Sudan supported al-Qaeda long after bin Laden left the Sudan and relocated to Afghanistan. When he arrived in the Sudan, he did deals with Tarabi and a number of Sudanese banks. 15% of their capitalization came from al-Qaeda funds. So Sudan is in the mix. Sudan is a fragmented, disastrous place now, but has enormous natural gas reserves. And if you can look ahead a number of years and Sudan is able to grow itself out of its mess, Sudan also is going to want to come off the list of state sponsors of terror. And like Iran, a condition should be clean up all the litigation. So I think for the next 10 years, you're going to be involved in it. Although I hope when it comes to 9/11, your job is a little easier because it's an equal sum per victim.
Steve, why can't the Iranian hostages and their families, why can't they get a default judgment? Why are they exempt under this statute from that requirement?
You know, at the beginning of today's session, we talked about the fact that I happened to have the Tehran hostage on my issue on my desk when I was working for the Senate. And that goes back to the document that President Carter negotiated with the Iranians that resulted in the release of the Tehran hostages. That document is called the Algiers Accords, and it gave Iran a grant of immunity. And that grant of immunity is not trumped by the subsequent 1996 amendment to the Foreign Sovereign Immunities Act, to the Flatow. It is not trumped by the Flatow amendment. In order to trump that that would be a 1979 or 1980 obligation, Congress would have to expressly repeal the Algiers Accord. That's not happening. It's just not politically feasible for Congress to roll back a binding international agreement. They have no remedy in the courthouse, so Congress, as a political matter, decided that it would include the people within that one event along with the other judgment holders.
Let me ask one more question of both of these guys, and then we'll take some questions for about 10 minutes before we break. Starting with Jim, we can't leave this crowd without asking your view, personal, you're not the be-all and end-all, what's going to happen with President Obama's veto of the Saudi legislation, and will that veto be overridden? And will you be able to, 9/11 victims be able to sue the Saudis in U.S. courts? What do you think is going to happen?
Yes, this week. The veto is upsetting because it just is not honest. Everything contained in the veto message is not true. Let's go back 12 years. The Justice Department itself said you don't need any legislation because a country that works with a terrorist group in the United States is subject to jurisdiction under the non-commercial tort exception. Non-commercial tort exception usually is applied to a case where a nation's embassy driver hits a pedestrian and can be sued for that tort. Well, if the country can be sued for an accidental death, it's absurd for it not to be suable for an intentional death. And those people who studied the issue long believed that the non-commercial tort exception would apply to 9/11. The problem was we began to get aberrant decisions from the court. And a lot of it is our fault. I mean, the 9/11 litigation is very complicated. When we first got into it, collectively there's 600 defendants, and we knew a fraction of what we know today. But we got bad decisions from the court and then affirmed on appeal, dismissing the case against Saudi Arabia. So what JASTA does is clarify that in that narrow circumstance where a country aids and abets a terrorist organization mounting a terror attack, it's suable. JASTA has nothing to do with suing government officials who are immune under our law, nothing to do with suing servicemen, nothing to do with suing diplomats who are immune, and the notion that this could invite reciprocal legislation is just a lie. I mean, you have 100 suits against the United States going on and a whole department of the State Department defending foreign actions, and there's nothing about JASTA that would change that circumstance. Now, what you hear, honestly, is an attempt to protect Saudi Arabia. And I think Congress recognizes it, recognizes it's wrong, and really very few people in Congress are going to drink the Kool-Aid. So if we get this veto overridden this week, that will put an end to this 15-year struggle about whether Saudi Arabia is immunized for the attack. On the facts are so damning and so overwhelming. I can't see how Saudi Arabia can continue. I mean, they can delay the case for a couple of years, but we know maybe 10% of what the Saudis did. And with what we know, could try the case 1,000 times and never lose it. So I hope and believe that overriding the veto will finally turn the corner.
Steve, you get the last word on the South with your prediction and why, and then we'll throw it open for a few minutes.
That's great. Thank you. First of all, I don't have any of the Saudi litigation, so
So, all right, you're a nice, dispassionate, objective observer.
I happen to agree with Jim's analysis that the non-commercial tort committed in the United States exception should have been the end-all and be-all and all that was necessary for him to proceed with his litigation. So I rather viewed JASTA as remedial legislation. I think the veto is going to be fairly overridden, and that the 9/11 plaintiffs will get their day in court. Jim has an advantage over me. I haven't, because it's not my case, I haven't reviewed the evidence, so I make no predictions as to how he will fare. I think those plaintiffs should have had their day in court under the non-commercial tort committed in the United States exception. And frankly, I think that the same was true when you originally tried Lockerbie. Pan Am Airlines flew U.S. flag aircraft. Those U.S. flag aircraft are soil of the United States. I think you should have been able to go through and litigate Lockerbie without the necessity. I'm glad you failed, because I couldn't have got it done for all these kids that were killed in Israel without working shoulder to shoulder with you. But I think that the non-commercial tort committed in the United States exception should have applied to Lockerbie as well. And I think it's quite unfortunate that you have jurists who pretty uniformly read this statute as narrowly as they possibly could, and then try and shrink it down another 25 or 30%.
We have about 10 minutes for questions. Frandy Wolf is really a tight ship. We got to follow the rules here, but we'll start right here with a question. I know a lot of the questioners, but I can't see them because of the glare.
The Obama administration gave $1.5 billion to Iran as repayment plus interest for monies that I guess had been owed to the Iranian government under a canceled aircraft deal with the Shah. Shouldn't that money have been turned over to your fund?
Yes.
Yes?
Yes.
And we spent some of it already. I mean, this is the interesting part about this. There's a statute called the Victims Act 2000, in which the $400 million, it's actually a foreign military sales account for military aircraft, was already turned over to victims. So apparently, Jim uses this word dishonest, talking about the rationale for JASTA. I find it dishonest that the administration would look at what happened in 2000 when that $400 million went to certain terror victims and say, we're just going to pretend we didn't spend that money and we're going to give it away a second time. And I've seen no reasoned explanation of how you take money in the Treasury and spend it twice but only count it once. It's just a dishonest way to conduct business.
Yeah.
And then another one down front here. Yes.
Thank you. I'm K.D. Raju. I teach international law in IIT Law School in India. My question is, the Pakistan has harbored the leader of global terrorism, Osama bin Laden. Why the United States not sued Pakistan for harboring Osama bin Laden? And that's one. And second question is, rather than suing the Pakistan, the U.S. has provided billions of dollars, which is the taxpayers' money, to the Pakistan for fighting against terrorism, which they produce as terrorists using against India. So what is the policy? This is a political decision, or what is the policy of the United States on these victims?
Yeah. Well, I also represent the Americans who were murdered in the Mumbai attack. And this was the problem we had, because Pakistan is not a state sponsor of terrorism, although factually it certainly could be. We know Pakistani intelligence directed the Lashkar-e-Taiba terrorists, and they were in the hotels in the Chabad asking people for their nationality and killing Americans, Jews, and Indians, and letting other people go. But it happened outside the United States. The State Department, I think, acted improperly there. What we did is we sued the ISI on the theory that the ISI is not accountable to Pakistani government, and you have the minister of Pakistan saying The ISI is often a rogue agency doing what they want and not under our control. Many people believe the ISI was responsible for the assassination of the former prime minister. And so we said, based upon official statements from Pakistan, the ISI should not enjoy immunity of the Pakistani government because it's acting independently according to the government of Pakistan. And in meeting with the State Department, my plea was just keep your mouth shut. Let the court decide. And I was trying to work toward a resolution. Unfortunately, the State Department, who often is not friendly to victims of terror, intervened and said the ISI and its officials should enjoy full immunity as the government of Pakistan does. But I agree with you that Pakistan has not been held accountable both for harboring bin Laden, the Pakistani-Saudi ties and moving arms and harboring al-Qaeda is an issue in 9/11, and Pakistan should not be given the free pass it has been.
Two more questions. Yes, sir.
When you gave out all the money to the families of the victims of the World Trade Center, did they have to sign a release or anything agreeing not to sue again? And if so, how's Steve Cozen going to sue again on behalf of these people after this law gets overridden? The veto gets overridden. How's he going to sue Saudi Arabia on behalf of these same people if they already signed a release that they're not going to sue anybody?
Because that release only governs domestic tortfeasors. In fact, at the time that we gave out that money, 2001, the federal compensation statute, even then, the statute made clear that the release that was required only applied to domestic tortfeasors like the airlines, Boeing, the World Trade Center, but had no bearing whatsoever on foreign actors or those who assisted the terrorists. So that's the wrinkle, that there's the opening. Plus, I assume that if that statute is enacted and the veto is overridden, that'll be spelled out even more clearly, expressly in the statute. Last question. Yes, ma'am.
My name is Edna Arbel. I was a state attorney for 9 years in Israel and for 10 years a Supreme Court justice. I would like to ask about another kind of victims or claims for compensations. But I will start with a little background. As you know, Israel is fighting terror since its independence. And we know all kinds of terror and all kinds of claims and all kinds of compensation. But one that was unique or unusual was when 2 terrorists entered to Israel and was captured by the Israeli soldiers. And they were kept in detention, in administrative detention, for the purpose of exchanging prisoners. The decision of the Supreme Court was after two levels of the court, the Court of Appeal, and then it was a wide panel that it's not allowed to keep them as prisoners for the purpose of exchanging prisoners. These terrorists, both of them, their name was Ubed and Dirani. Maybe they are known here because they captured the Israeli prisoner soldier Ron Arad, that till today we don't know if he is alive or not, and they tortured him. They were released, as I said before, and then one of them sent a claim to Israel that he wants compensation because he was tortured during his detention and because he was raped. This case is still now pending in the Supreme Court, and I would like to ask your view to this position, very different position, and difficult one.
Steve?
Well, this is not my usual cup of tea. We have had similar kinds of actions brought in the United States for the by individuals who have been the subject of what we call aggressive rendition. And some of the panelists who are much better qualified to talk about this than I am addressed this question this morning. In the United States, all actions for compensation against the United States as a result of aggressive rendition activities have failed. Okay? They have uniformly failed. Okay.
Ladies and gentlemen, before we break, I want to close by just reminding people here that the members of the legal profession, myself, lawyers, Ike, others, we're all members of a profession where we are supposed, as part of our professional obligation, to serve the public interest. I know of no example of lawyers more dedicated to that principle of serving the public interest than my fellow panelists, Jim and Steve. I want to, as you can tell in the last hour, it is a very complicated, grueling area of law that we're dealing with a lot of unknown questions, a lot of political interference. It's not easy, it's grueling. And I think what Jim and Steve and others that are here today in serving the public interest bring forward the best in our legal profession. I thank you. I thank American Friends of Hebrew University. Thank you.